So good afternoon, everyone, and I hope I would be able to deliver the entire knowledge that is needed for your business, give at least some clarity to move ahead, how to use intellectual property in various ways, and how it can add value to your business, and definitely what are the government schemes that you can utilize. Okay. After each subject, I will be giving you the government schemes that are there for each kind of a category of intellectual property. Okay. So just to give you my background, I'm a mechanical engineer, patent agent. I'm not a trademark agent or a attorney. I'm a patent agent, qualified patent agent, registered with Indian Patent Office, and I have total 17 years of experience, and I'm a visiting faculty with Pune University and RGNIT. So I have two companies, Brainiac Global Consulting Private Limited and Brainiac IP Solutions. Okay. So why IPR is important for every business? Because now what has happened is earlier valuation of each business was made on the assets they had. Assets, when I say, those were physical assets. How much land do you have? How much machinery you own? What are the infrastructural facilities that you have? Based on that, valuations were done actually. Nowadays, those valuations are irrelevant because everything can be outsourced. In India as well, most of the companies are getting their product manufactured, branded from other countries, and they are just selling it in India. So with zero infrastructure capacity or facility, they are able to do it. And same thing you can do. That is the reason for, just for an example, if you want to buy the companies like both, they don't have much infrastructure, but its valuation is very high. It's only because of their brand value. They have such a big valuation for their brand. Okay. And there are many other similar companies. Okay. And there are traditional companies like Mahindra, Tata, who have manufacturing setup as well. So they have a double valuation, IP as well as their assets, physical assets. Okay. So second important thing, you have to create asset. That is one thing. And second, you don't need also to lose assets. You need to protect your assets. It's very important to protect your assets. If you have something innovative, as simple as that, why your clients work with you? There could be multiple reasons. For me, one of the reasons is we are very proactive and give them information very clearly, real time. We update them, we are approachable. For you, it may be different. There may be some other strategies which help you to retain clients. Imagine if this kind of features, this kind of things are gone out, and you see that competitors are doing the same thing, or someone from your company who has left and takes away the important thing that is very important for your business. It is a huge loss for the company. So there are various reasons why protecting your intellectual property is also important. And most of the times, the valuable assets are always taken by the people who are at a seniority positions. Okay, either maybe they're senior employees, partners, or your what I can say, fellow colleagues. Okay, so apart from that, definitely preventing competition, yes. Increasing market share, yes. This also can happen with intellectual property. Okay, there is no other asset like patents and trademarks which can refrain your competitors from entering into market. Specifically patents, it's applicable if you have innovative products. Otherwise, trademark, if you have a very good business, every business needs a trademark. Maybe patent may not be required for every business. Okay, patent may be required only for the businesses who have their own products. Okay, so I will start with to ensure that you don't lose your business to your closest allies and prevent your competitors from using your goodwill. Okay, so I will start with the intellectual property and various facets of intellectual property. What is intellectual property? So anything that is created from your mind is considered as an intellectual property. Okay, anything. Okay, and when you protect it, it becomes property. If you don't protect it, it is open to all. Everyone can gain the knowledge and use it. So that is called intellectual work. Like books, these are intellectual work, theories that are intellectual work, which are open. But if you want to prevent someone from using it, then you have to register and protect it. Then it becomes intellectual property rights. Okay, like other intellectual property rights, like other intellectual property rights, it also can be bought, it can be licensed, it can be sold. It's very much similar to other intellectual property rights. The advantage of this is you can sell it to one person, but you can license it to a multiple people, multiple assets, or multiple companies. Okay, just for an example, McDonald's. McDonald's is a brand name. Okay, I own it. So just an example I'm giving you. I don't own it. Okay, if I own it, and if I want to start giving franchises, I can give them a license to use it, right? Okay, so this is how franchises work. The value is of that particular brand. Okay, you can give it to multiple people. But for example, if you have a corporate premises, you can lease it to only one party or one corporate entity, right? So that is a limitation, and this is the advantage for intellectual property. Okay. Next thing is, if you are an inventor, or if you are a serial entrepreneur, okay, your intellectual property will never get exhausted by consumption like other properties. For example, if I have a land, I constructed building over it. I cannot reuse it, that particular land, right? But with intellectual property, you can create multiple assets. It's only because of your mind. Okay, that's the beauty of intellectual property. So intellectual property is an important tool used to protect and enforce the right of the inventors, creators, and businesses. It can be used as both a weapon and as a shield in terms of protecting one's ideas and creation from being misused or copied without permission. As a weapon, it can be used to take legal action against those who infringe upon the rights of the intellectual property owners. As a shield, it can protect the owners from being illegally used by others. Okay, this is a what I can crux of intellectual property. Okay, in short. As I mentioned, it is like an asset. It can be bought, it can be licensed, it can be sold. You can take legal action against the unauthorized use. Okay. Differences: it is not exhausted by consumption, and it is intangible. So, how do you create intellectual property? So, most of the times, whenever you solve a problem, you automatically generated an intellectual property. Maybe it's a new business to solve one problem. Maybe it's an invention to solve a problem. Every time you are solving some problem of humanity, there is always creation of intellectual property. There is always creation of intellectual property. Sometimes for inventions, specifically who are the inventors, they think that they have to create a benchmark inventions, disruptive inventions, like for example, fuel cells, batteries, or I can say touch screen. No, small improvements also are inventions, innovations. Those also can be protected under patents. Just to give you an example, Nokia has over 6,000 patents on 5G technology. Just to give you an example. Okay, 5,000, and they are licensing their patents to everyone. Even if they don't sell a single mobile phone, they would be happy because they are still making money. Okay, so how this is always done, because you are solving some problems that are faced by humanity. So if you think that you have solved some problem, definitely also think about whether it can be protected under any facet of intellectual property. Okay, when you protect it, definitely you get recognition. Okay, Thomas Edison, everyone knows he has a lot of patents in his name, right? 1,000+ patents. He's been recognized. Just a good example from Bollywood movie, Fungsuk Wangdu, Three Idiots, 400 patents, just to give you an example. Okay, and there are many serial entrepreneurs, okay, those who get recognition because of their business or because of their intellectual property as well. You stand out in the crowd if you want to opt for fundings, if you want to opt for some association, if you have intellectual property in place, investors or someone wants to join hand with you, they will be willing to do it because you have some control on misusage of your assets. Okay, so that is the reason it's again important. And definitely everyone wants to earn money. Okay, everyone wants to earn money. That's the reason we spend money on businesses. But from businesses, we spend money for ourselves. But when it comes to business, everything drills down to how much ROI I am going to make. So definitely it will give you returns on your investment, but it will not be in a direct form. Okay. Always returns are in the form of reduced competition or increased market share. So these are the only two parameters that you have to cross check whether your intellectual property is working well or not. Unless and until you sell it, like for example, you want to sell your company, a brand name itself, for example, okay, then you can value it tangibly. But if you're not willing to sell it, it's always intangible. Leave about what is the turnover of your company. The turnover does not justify um, the actual value. Okay, if the turnover is day by day increasing, the valuation of your IP would be much higher. Okay, so still it's little difficult to give tangible valuation to the intellectual property. In India, valuations are normally done based on sales, how much sales you are doing, but that is not the real valuation, I can say. Still, people are figuring out how to value it. Okay, but as of now, tangible valuation is done based on only sales, but it's not that correct, I can say. Okay. As intellectual property is a negative right. Okay, so intellectual property is a negative right. Means what? You earn money. You earn money by stopping others. The more you stop others, the more uh, your income will increase. Okay, that is the reason it is considered as a negative right. Negative right. Okay. The more entry barrier to your competition, more sales of your product will happen, or more market share will be captured by your company. This is how it is. Okay. So this is a negative right because you stop others. Okay. So these are the different facets of intellectual property that we are going to cover today. Trademark, copyright, design, patent, trade secret. I will not be covering much on IC circuit layout and plant variety protection. Maybe that may not be relevant to you. I will take some overview on IC circuit layout, but not on plant variety protection. Are there any farmers over here? Anyone into agriculture? Just raise your hand or just type me in the chat box. Anyone from agricultural domain? I assume there is no one from agri domain. Fair. So how to use this? Okay. So how to protect your business as an entrepreneur? Okay. So just to start with a small example, actually. So nowadays, chai has become a big business. Many people have earned a lot of money and fame because of chai. Okay. So for example, this is a matka chai that is just I'm showing you. So first thing that you need to do is when you have something like this, to protect it under the brand name. Okay, give it a brand name. The brand has that value. The brand will have the valuation. Okay. So can anyone tell me any big brand that they know about chai who is doing great? Chai. Anyone example? चाय का business बहुत बढ़ गया है अभी. Everyone there with me? How is it?
Yes, everyone is there and they're listening to you.
Okay, okay. Fair enough. So I will move on. So tandoor chai or matka chai, this is called. Okay, this is tandoor chai or matka chai. So the famous brand that we have seen recently is NBA Chai Wala. Okay, so that has become a big brand. Apart from that, these are the various brands that are selling chai. Just to give you an example, Chai by Azad, Chai Bolo Chai, Chai Wala, BBA Chai Wala is there. In Pune, I stay. There is Engineer Chai Wala now. Tandoor Matka Chai, Chai Babu Chai. So these are the various brands that are selling chai. So when you want to protect a brand, when you want to protect a trademark, you cannot have protection for the word chai. Okay, chai is a generic word, dictionary word. You cannot refrain anyone from using this chai. Okay, everyone is allowed to use chai. That is the reason you will see that these people have not used only chai, but they have added something before, and specifically these are in a logo format. Okay, when it is a logo we call it device. name plus logo. MBA, okay, MBA Chai Wala. He has a different logo. Chai Chai has a different logo. Chai Wala has a different logo. BBA Chai Wala has a different logo. So when you combine the name with the logo, it is called a device mark. Okay, because you cannot have protection on chai. So specifically tandoor matka, this is a very generic word. You won't be able to get protection on this. BBA is already a degree, right? And chai is already there. So BBA chai wala, you won't be able to protect because BBA has already been used uh, in academics. Chai wala is everyone who is selling he is chai wala. That is the reason it's a logo. That is the reason it is name plus logo device mark they have used. Okay, so just to give you a clarity, generic words, when it becomes difficult to protect, you have to combine with the logo. So it becomes device, and those devices can be easily protected. So whenever you have such kind of a name, or whenever you want to start any business, first step is what you is that you give a name to it, right? First step is always giving a name to the business. So whenever you are giving a name to the business, people generally what they do is they just get a registered company. They register a company first. Either it is a private limited or proprietorship or a what I can say partnership company, and then they try to get a trademark registration. But I would recommend first check whether you can get a trademark and then go for company registration. Okay, why? Because there are possibilities. If there are any possibilities that in future, if someone is thinking or assume that there is a conflict and if they take legal action against you, and if at all you have had to withdraw, you have to withdraw your trademark from the business, from the market, it will be a huge expenditure because the marketing expenditure that you are doing on your brand will be wasted, entirely wasted. So a recommended step would be first, whatever comes to your mind before launching your business or launching a product, before giving a name or finalizing a name, whatever comes to your mind, first check whether you can get a trademark. Second, whether it is available. Uh, are there any infringement possibilities? Will you attract infringement on it? Okay. Third, if at all you want to take your business globally, it is also recommended that check whether in other countries you have this trademark available. Otherwise, if you want to enter other countries, in those countries, maybe you have to change the brand. And then it may become difficult to market or what I can say, do extensive marketing by your Indian name over there. Okay. So depending upon the extent that you want to go, the search has to be conducted. So there are two searches. One, whether you can get a trademark. Second, whether there will be any possible infringement. A clear trademark is always better. Okay, because you may lose your entire expenditure that you have done on marketing. I hope this is clear to everyone. Okay, so first go for trademark. If it is clear, register a trademark and then go for company registration. So trademark is a sign that distinguishes the goods or services of a given enterprise and distinguishes them from its competitor. Okay, trademark as a mark is capable of being represented graphically and which is capable of distinguishing the goods or services of any person from the other and may include shape of goods, their packaging and colors. Okay. Trademark defines mark as including a device. Device I already told you. Name plus logo, it is a device. Brand, heading, label, ticket, name, signature, word, letter, number, shape of goods, packaging, or combination of colors or any combinations are considered as a trademark. Okay, in a particular combination. So signature, the basic classic example is Kirloskar. Kirloskar is a brand is a signature of Mr. Kirloskar. Numbers, there are various numbers. Okay, 3M, they are using number. Okay, Triple Fry, it's a brand that is using numbers, and there are various numbers that are used as a brand. Okay, shape of goods, there is only one that has been protected under trademark, that is Coca-Cola bottle. Apart from that, no one has received trademark protection on the shape of goods. Recently, Crocs shoes tried to get a protection on their design under trademark, but they failed actually. Okay, so as on date, there is only one bottle that is protected under trademark, that is Coca-Cola shape of goods. Okay, so as I mentioned, what you can protect is name of your business, okay? Logo of your business, okay? So by just seeing at the logo, you would be able to recognize which companies are this, right? So first is Audi, Tata, Toyota, Jaguar, okay? So given a choice, if you have a choice and if you have budget, okay, so I would recommend you should always go for a word mark which is generic, which is which is unique, and you should also have a separate protection for the logo. What does it will what advantage you will get is, if you have a protection for your name, at any given time you can change the logo, like Google does it. Always they change the logo, right? Because Google, they have a protection as a brand, and logo they are continuously revising. But if you're taking protection as a device where you are combining name plus logo, it's a weak protection, I can say. It's a weak protection. So best protection is separate protection for the word and separate protection for the logo. In worst case, if you want to stick to the same words, then you can combine it together to get a device mark. Apart from name and logo, what can be protected is sorry. जस्ट आई विल गिव यू द क्रक्स इन हिंदी. अगर आप नया बिजनेस स्टार्ट कर रहे हो ना, तो उसका नेम जो होता है, उसका पहले ट्रेडमार्क कराना जरूरी है, उसके बाद आप कंपनी रजिस्टर कराइए, ओके? अगर आपके पास चॉइस है, आपने अगर यूनिक नेम कॉइन किया है, तो नाम अलग से और लोगो अलग से अगर प्रोटेक्ट होता है, तो दैट इज अ बेस्ट कॉम्बिनेशन. वो बेस्ट कॉम्बिनेशन है. इन वर्स्ट केस, अगर आपको नाम चेंज ही नहीं करना है बट प्रोटेक्शन भी चाहिए, इन दैट केस नेम प्लस लोगो आप कंबाइन कर सकते हो, तो उसको बोलते हैं डिवाइस मार्क. दैट इज अ वीक प्रोटेक्शन, ओके? सो नेम अलग, लोगो अलग, बेस्ट प्रोटेक्शन. कंपनी रजिस्ट्रेशन या प्रोडक्ट रजिस्ट्रेशन, ब्रांड रजिस्ट्रेशन से पहले आप ट्रेडमार्क कराओ, एंड देन गो फॉर एनी काइंड ऑफ रजिस्ट्रेशंस विद दैट पर्टिकुलर नेम. ऐसा हो सकता है कि आपने यूज किया, बट किसी को लग सकता है कि आप किसी का ट्रेडमार्क इन्फ्रिंज कर रहे हो. अगर आपने ट्रेडमार्क इन्फ्रिंज किया, तो बहुत नुकसान हो सकता है. क्यों? बिकॉज अगर फॉर एग्जाम्पल आपका नाम आज जस्ट एन एग्जाम्पल, एप्पल आपका आज ब्रांड है, जिसकी वजह से सब आपको जानते हैं. अगर आपको एप्पल की जगह कुछ और नाम रखना पड़े, तो कितना ब्रांडिंग पे खर्चा होगा? ह्यूज अमाउंट टू टेल पीपल अगेन, नहीं भाई, एप्पल मेरा ब्रांड नहीं है, अभी ये है, आई एम स्टिल द सेम. सो इट्स अ ह्यूज एक्सपेंडिचर. ट्रेडमार्क सबसे ज्यादा वैल्यूड एसेट है. दैट इज रीजन इट्स मोर क्रूशियल फॉर योर बिजनेस. ठीक है? सो पहले नाम ट्रेडमार्क होता है कि नहीं देखिए, फिर कंपनी रजिस्टर करिए. नाम यूनिक है तो बेस्ट, नहीं है तो उसके साथ लोगो मिला दीजिए. दैट इज व्हाट यू कैन डू. ओके? सो अपार्ट फ्रॉम नेम, नाम के अलावा व्हाट कैन बी प्रोटेक्टेड? कलर, साउंड, जैसे फॉर एग्जांपल हॉर्न्स, व्हीकल हॉर्न्स, गाड़ी के हॉर्न्स, ओके? स्मेल, इंडिया में सेल्फ वी कैन नॉट प्रोटेक्ट स्मेल एज इट नाउ. परफ्यूम स्मेल्स, इन फॉरेन कंट्रीज देयर इज अ प्रोटेक्शन फॉर परफ्यूम स्मेल्स. परफ्यूम स्मेल्स का प्रोटेक्शन इंडिया में अभी नहीं है. ठीक? शेप, आई टोल्ड यू, देयर इज ओनली वन शेप दैट वी हैव गिवन ट्रेडमार्क टू. हॉलोग्राम्स, मार्क्स, एनिमेशन, जो मूवीज के एनिमेशंस होते हैं, उसको भी ट्रेडमार्क मिलता है. सो एनिमेशन दैट begins with the movie, or any other animation that you are using for branding, right? So those also can be protected under trademark. So just for your understanding, okay, just to give you an understanding, what is the value of a trademark? Okay, leave about their physical assets, their employees, आप कुछ भी सब छोड़ दो. If you want to buy the name Tata Consultancy Services, so you have to spare $45 billion. सिर्फ नाम का वैल्यूएशन, बाकी बिजनेस का अलग है. ओनली ब्रांड नेम. सेकंड इज HDFC, देन Infosys, Airtel, Asian Paints, State Bank of India, LIC, Kotak Mahindra, and ICICI. These are the biggest brands and biggest, highest valued brands in India. World's highest brand is Amazon as of now, and Apple. Okay, these are the world's highest brands as of now. So कुछ भी नहीं है, सिर्फ if you want to sell name, TCS से बेचना है, so this can be a valuation. If you are a startup owner, or if you have a startup and if you are aspiring it to grow to the next level, बढ़ाना चाहते हो उसको, and किसी का हो सकता है कि आइडिया कि मुझे बेच देना है, मुझे ज्यादा काम नहीं करना। ओके, तो ट्रेडमार्क का आप अलग से वैल्यू कर सकते हो, बिजनेस का अलग वैल्यूएशन कर सकते हो। पेटेंट्स है तो वो अलग फैसेट है, वो अभी आगे देखेंगे, विल सी पेटेंट्स लेटर ऑन। So there is another category, well-known marks. Well-known marks like Tata, Mahindra, Bajaj. So these are considered as a well-known mark. Earlier, government used to recognize those marks as well-known marks, but now you can apply for well-known marks. Okay, there are 45 categories, there are 45 classifications based on your goods and services. आप trademark file कर सकते हो, 45 classifications. अगर आप सर्विस दे रहे हो तो there are different classification. प्रोडक्ट्स है तो अलग क्लासिफिकेशन है। आप जो क्लासिफिकेशन में काम करते हो उसी क्लास में आपको प्रोटेक्शन मिलेगा। अगर आपको ऑल 45 क्लासेस में प्रोटेक्शन चाहिए तो उसको वेल नोन मार्क बोलते हैं। सो दिस इज अ वेल नोन मार्क which will give you protection in all 45 classifications. So the extent of use, enforcement, promotions, these are considered to give you a well-known mark. Now you can apply it. The fees is somewhere around 1 lakh, government fees is somewhere around 1 lakh rupees. But if you have all these criteria fulfilled, you can get a well-known mark. Okay. So we are trying for our brand to make it a well-known mark. Okay. Which means, agar, for example, if you're selling shoes, just an example, if you're selling shoes, no one can sell even what I can say bread using your same trademark. Okay. Otherwise, what you will see is there is one brand which can be one name for one particular class. It can be also used by some other person in another classification. Okay, this generally happens. Okay? So, for example, my name Brainiac, we have registered in 3 classifications. One is education, consultation, and legal. 3 classifications, and we are also entering into product line in future. We will be registering in that also. Okay, so based on your goods and services, you can choose a class. In that particular classification only you can get protection, or you can seek for protection. There is no need to go into other class if you don't intend to expand your business. But agar aapko future dikh raha hai ki I want to expand and get into everything, then well known is what you should consider. अगर आपको बहुत सारे बिजनेसेस करने हैं अलग अलग डोमेन में, तो वेल नोन मार्क जरूरी होगा आपको फ्यूचर में. Good mark and bad mark. How to choose a trademark? Good mark, it should be distinct. अलग होना चाहिए दिखने में, बोलने में. जितना अलग उतना बेहतर. Capable of graphical representation. If you are able to represent graphically, very good. Easy to speak, spell and remember. Easy, बात करने में, प्रोनाउंस करने में इजी होना चाहिए और दिमाग में रहना चाहिए. बिकॉज द ब्रांड जितना आपके दिमाग में रहेगा उतना वैल्यू बढ़ेगा उसका, राइट? Easy to speak. Why? Because something that is in Chinese, we won't be able to speak it well. Still, I have a problem in pronouncing Xiaomi. Still, I don't know whether I'm correctly pronouncing it. Okay. Hawaii, I don't know whether I'm really pronouncing it correctly. These are difficult pronunciations. So they have not adapted to different geographies. That is the reason it is not little good for Indian geography, I can say. But still, they are doing good business. Okay. Invented or coined words. Next is anything that is there in the dictionary, you should not pick it. That is what is recommended. If you are combining 2 words together, 3 words together, okay, and creating something unique, okay. So in that case, it would be a good mark. It would be a good mark. Every time it is not possible, but if at all you are able to coin a word which is not there in the dictionary, it is the best word that I can say. So just in Hindi, I will translate. If आपके पास अगर एक word है जो dictionary में available नहीं है, so that would be the best thing. अगर आप 2 words को combine करके नाम बनाते हो, 3 words को, या कुछ भी ऐसा जिसका meaning नहीं है वो use करते हो, that is the best thing. So just I don't know, but Nike, I have never seen a dictionary name of it, but some people say it is a surname. I don't know, but Nike seems to be a coined word. Unique. Adidas, I don't know what is the meaning of it. Okay, so these kind of names are good for trademark. bad names which are phonetically similar. So what sometimes people do is Cotton King, for example, in our area, there is a brand Cotton King, which is working well. Okay, so someone thought of just changing the K to make it C and K and add a few O's in between and then sell it. So it's a bad strategy. Definitely, these people will pursue you. Okay, so anything that is phonetically similar, you should not use it. Make sure that it is sounding also different. Even if the spelling is same, different, it does not mean your trademark is unique. When you pronounce, it has to be different. Okay. Uh, you are allowed to use geographical names. Everyone is allowed to use geographical names, but those geographical names will not be protected. Okay. Darjeeling tea. Darjeeling is well known for its tea. So Darjeeling tea, अगर डालोगे तो you'll never get protection for Darjeeling word. Tea के साथ you add anything. Okay. Anything, for example, Sholapur chadars are there. Okay. So these geographical names, sometimes people try to align. Okay. So those names will not get protection. Whatever you use after that, you can get protection on that. So no Bharat automotive, for example, Bharat automotive will not get protection on Bharat word. Everyone is allowed to use. But if you're creating a logo out of it, definitely you can get it. Okay? Just an example. Anything that is praising the words, praising good quality silk, never. Deceptive, which is creating deception, those are not allowed. So just I'll translate it in Hindi. Phonetic similar, जिनका जब आप प्रोनाउंस करते हो कुछ भी वर्ड अगर वो प्रोनाउंसिएशन में सेम है तो लेना is a bad strategy. Protecting it under trademark is a bad strategy. Spelling change करके protection is a bad strategy. Geographical names भारत, इंडिया, शोलापुर, पुणे, महाराष्ट्र, पंजाब, इस नेम को आप यूज कर सकते हो बट इसके ऊपर मोनोपोली आपको कभी नहीं मिलेगी. ठीक है, ना आप किसी को रोक सकते हो ना आपको कोई रोक पाएगा. ठीक है, तो यूज करिए बट आपको प्रोटेक्शन नहीं मिलेगा उसके ऊपर. उसके बाद आगे पीछे या उसका लोगो बना के आप जो भी करते हो उसके ऊपर आपको प्रोटेक्शन मिल जाता है. ठीक है, क्रक्स ऑफ दिस. So whenever you file a trademark, you can write TM superscript, and when it is registered, you are allowed to write R. Okay, so writing TM without applying a trademark and also using R without getting a registration is a legal offense. It's legally offensive. So make sure that you use it properly. Don't mislead the people. Okay. अगर आपका ट्रेडमार्क फाइल हुआ है तो आप टीएम यूज कर सकते हो, अगर रजिस्टर्ड हुआ है तो आर. ओके, सो ट्रेडमार्क का प्रोटेक्शन is for 10 years. Trademark is protected for 10 years, but it can be renewed perpetually. Okay. By giving renewal fees, it can be renewed perpetually. This is the only brand that can go from one generation to another generation. Over the centuries, it can go. There is no other facet of intellectual property that can go from one century to another century. Trademarks only can go perpetually. So trademark registration 10 साल के लिए वैलिड होता है, बट आप इसको आप रिन्यू कर सकते हो एवरी 10 साल. तो ये परपेचुअली प्रोटेक्ट हो जाएगा आपका. एवरी 10 साल अगर आप इसको रिन्यूअल फीस देते हो तो आप ये परपेचुअली इसको प्रोटेक्शन मिल सकता है. व्हाई? बिजनेस का नाम आप चेंज नहीं कर सकते. यू कैन नॉट चेंज द नेम ऑफ द बिजनेस. दैट इज रीजन इट हैज टू गो परपेचुअल. Okay. So Madrid system is there. It's a facility to file your trademark application in multiple countries in a cost effective way. अगर आपको multiple countries में file करना है तो ये system है. So I will not take much on this Madrid system. It is little cost effective. In from India itself you can process everything. India से ही आप सब processing कर सकते हो. अगर कोई ऑब्जेक्शन आया तो ही लोकल अटॉर्नी या एजेंट को कांटेक्ट करना होगा, अदरवाइज इट्स नॉट रिक्वायर्ड. Sorry, I am having little cough up. That's the reason it's cold. So as I told you, first step, trademark search, check infringement and possibilities and availability possibilities. First step. Okay. Second is filing a trademark. Then it goes for examination, hearing, registration, refusal, and renewal. Okay. This is general procedure. The costing for trademark. Okay. So I'll just get back to the costing of the trademark as well. So it's a civil suit only. It's not a criminal suit. This is something old slide. So what you have to avoid is deceptive trademarks, phonetically similar trademarks you have to avoid. Similar logos you should avoid. Similar trade dress or color codes also you should avoid. Similar packaging also you should avoid to avoid infringements. Okay. Recommended steps: coin or choose a unique word or combination. Trademark search from experts, local, global. Then register the trademark and then go for company registration. Okay. So government schemes. If you are a startup, if your company is a startup, then you can approach facilitators actually on startup website. Startup ki website pe hi, there is a list of startup facilitators. There is a separate list for trademark and separate list for patents. Okay, so my company is not in that particular list because government ka paisa aana is always a task. Government doesn't pay. Okay, but this is a facility. Okay, uh, by choosing anyone from that particular list, they can do a trademark with zero professional fees. With zero professional fees means what? You have to pay government fees only. Apart from that, their professional fees will be paid by Indian government. Okay, but check whether these people are expert enough. Sometimes because of the cost problem and this problem, they may not be that good. So finding a good resource is your task, but these are there. So startup facilitators, it is also all available on startup website. Okay, 50% reduction on professional fees for startups and for MSMEs, both. So normally government fees is around some 9,000 rupees for one trademark in one classification. Okay, so the fees would be reduced if you are an MSME or a startup or an individual applicant by 50%. So it will be straight 4,500 rupees plus professional fees. Professional fees can vary from 5,000 to 15,000 depending upon the complexity of your trademark and the expertise of the firm. Okay, so professional fees can be somewhere around 5,000 to 15,000. So just a summary of it. So whenever you are starting the business, first is go for trademark and then go for company registration. First trademark, then company registration. Okay. So just I'm using him as a example. Okay, nothing to do with him. So next is trade dress actually. So if you have restaurants, if you have any shops, so those things, if they are, if you're not able to protect their trade name, you can protect your trade dress also. Trade dress means, for example, whenever you walk into a Starbucks, you'll see same atmosphere, same interiors. You'll have same interiors. Their counters are arranged in the same way. Color combination is same. Fall ceiling is same. Same is with barista. Same is with Magdi. Okay. Rolls Royce, they also have trade dress actually. Okay. Rolls Royce. Coca-Cola bottle. Okay. So, so these things also can be protected, and based on this also you can enforce. There was a recent case actually, Annapurna. There were two restaurants. We were dealing with that particular case. There were two restaurants. Both were using name Annapurna. As the name is Annapurna, नाम अन्नपूर्णा था, तो इसके ऊपर प्रोटेक्शन नहीं मिलेगा. इट इज अ नेम ऑफ गॉडेस. नेम ऑफ द गॉडेस, इसलिए प्रोटेक्शन नहीं है. अन्नपूर्णा नहीं मिलेगा. So name of the goddess, no protection. So both started using the same name, but one was established person, second started little late. दूसरे ने थोड़ा सा बाद में बिजनेस शुरू किया था. तो पहले बंदे ने एक अपना इंटीरियर का सेटअप बहुत अच्छे से बना के रखा था. जो नेक्स्ट वाला बंदा था, उसने उसका सिर्फ इंटीरियर अरेंजमेंट कॉपी किया. नाम के ऊपर तो प्रोटेक्शन नहीं था, ट्रेडमार्क. ओके, सो जो इंटीरियर का कलर कॉम्बिनेशन एंड थीम था उसके ऊपर हमने केस डाला था एंड दिस गाय won actually. We were able to give justice to the person who was old in that particular business. So this is also equally important. If you have a chain of restaurants, if you have product uh, or anything that is that where you can apply, if you're able to continue the same theme, then it would be very effective to take legal action against others. Okay. Just give a thought if you are having any restaurants or premises. Okay, premises, any kind of premises that you are leasing out or renting out. Okay. So I will not take much of this. These are the famous cases actually. Colgate Palmolive Company versus Anchor Health Beauty, Feroz, Ferro Spa, Ruchi International. So you have any questions on trademark? I'm open to take any questions on trademark as of now. आपके पास अगर क्वेश्चन है कोई ट्रेडमार्क के, ट्रेडमार्क इज ओवर. Thank you, Adidas ka name, but Adidas doesn't have any meaning, right? Adidas dictionary meaning. Pushkaraj, thank you for that. I'm speaking in my full volume. I don't know how it is sounding. I hope. Okay, great. So I got one thumbs up. So I have 3 hands over here. Can you you can unmute and speak if you want to, but it's old. Santosh, you want to speak something?
Can you please unmute Santoshi so he can ask this question directly? Yes, please ask Santoshi. What is your question? I think Mr. Nath is there.
I think they are listening and speak mode. Disable to talk. ठीक है. Anyways, if you have, you can type it down.
Hello.
Yes,
Yes,
please.
Santoshi. Good evening. Please ask your question.
दरअसल मेरे को ट्रेडमार्क से रिलेटेड इशू है कि मेरा जब रजिस्टर्ड हो गया था
हाँ.
और 2 या 3 दिन हुए थे और किसी ने अपोज फाइल कर दिया है
हाँ.
और
Okay.
उसके बाद अब वो पूरा जो तकरीबन जो हमारा 2019-20 से जो हम लोग मेहनत कर रहे थे
हाँ.
वापस सारा का सारा वो स्टॉप हो गया. अब हमें जो पर्सन ने किया है वो लगभग डमी है सारा कुछ.
हाँ.
अब उसके चक्कर में हमने जो इतने टाइम से मेहनत करे तो हमें वापस हमें हर एक चीज प्रूफ करना पड़ रहा है.
करेक्ट. इसलिए पहले आपने अगर ट्रेडमार्क फाइल किया होता ना, बहुत पहले जब ने बिजनेस शुरू किया है, तब ये चीजें
जी.
आसान हो जाती. अभी जो आपको है वो फाइट आउट तो करना पड़ेगा. देखिए आपको लीगल बैटल तो शुरू हो गया है, आपको ये प्रूफ करना तो जरूरी है सब कुछ. बट ट्रेडमार्क जब अपोज होता है ना, तो गवर्नमेंट यानी जो एग्जामिनर्स होते हैं तो वो
हाँ
ये
जी.
चीजों में ज्यादा ध्यान नहीं देते, वो लास्ट प्रेफरेंस देते हैं, बिकॉज इसमें तो थोड़ा प्रॉब्लम होता ही है. तो हमारे भी जो अपोज ट्रेडमार्क है उनको बहुत पुश करना पड़ता है ताकि वो हियरिंग तक आए. नहीं तो नहीं आते वो बहुत जल्दी. तो आप जिनके साथ काम कर रहे हो उनको बोल दीजिए थोड़ा पुश करे मैटर्स एंड आप जल्दी से रिजल्ट लाए. बट एविडेंसेस तो आपको देना पड़ेगा. देयर इज नो वे आउट.
हाँ, एडिवेशन तकरीबन वो तो मैंने सारा कुछ किया हुआ. तकरीबन 40+ में मैंने उनको बोला है. लेकिन तो क्योंकि पहले तो ऐसा लग रहा था कि हाँ जो वो, बट रजिस्टर्ड होने के बाद ये चीजें होती थी. ये वेरी डेंजरस एक्सपीरियंस था ये मेरे लिए.
नहीं है यही तो, इसलिए तो थोड़ा सा कॉशियस होना बहुत जरूरी है. अगर मैलिशियस इंटेंशन है तो उसके लिए कुछ नहीं कर सकते. जो लीगली आपको अपोज कर रहे हैं उनका सीरियसली हम ले सकते हैं, उनका चेक कर सकते हैं. बट ऐसे ही कर रहे हैं वो जिनका अदर इंटरेस्ट है, वो कभी भी आ सकता है एक्चुअली. उसका तो कुछ गारंटी नहीं दे सकते.
नहीं, जो हमने किया है उसको ये भी नहीं पता कि मेरा ब्रांड नेम, कंपनी नेम, हर एक चीज ऑन है. सारा कुछ खुद का है जो हमारी सारा कुछ. उसके बावजूद भी एज पर सिर्फ डिले एंड टाइम पास, बस यही चीज है. अब जिसने खराब करना था वो खराब कर ही दिया बंदे ने.
अभी देयर इज नो ऑप्शन. आपको बैटल फाइट आउट तो करना पड़ेगा, ऐसा है.
बस वही चीज है.
करना तो पड़ेगा, अभी आ गया है तो ठीक है। तो ऑल द बेस्ट मैं आपको बोलूंगा। सो और कोई क्वेश्चन है ट्रेडमार्क?
Mr. Nath, would you like to ask your question now? Niroj Nath ji. Unmute him so that he can ask his question.
Okay.
Am I audible?
Yes, yes. Please ask your question.
Sir, good evening, sir.
Mm-hmm. Good evening, please.
Yeah, sir. Actually, my question is,
Uh-huh.
हमारा एक कंपनी है स्वादिष्टम फूड प्राइवेट लिमिटेड के नाम से।
हाँ।
तो अगर हम स्वादिष्टम फूड के नाम से ट्रेडमार्क लेंगे,
हाँ।
तो क्या उसमें कुछ फर्दर इंफ्रिंजमेंट आ सकता है एज पर योर एक्सपीरियंस?
सर्च करके देखना पड़ेगा। स्वादिष्टम ये वर्ड तो अपना डिक्शनरी वर्ड हो गया ना पहले तो।
ओके।
तो स्वादिष्टम के ऊपर आ सकता है अगर किसी ने यूज किया है पहले से ही, तो देखना पड़ेगा। ऐसे ओपनली मैं नहीं बोल सकता, बट सिंपल लॉजिक है। स्वादिष्टम वर्ड डिक्शनरी है तो पॉसिबिलिटी तो होगा ही।
ओके, तो मैंने सर्च किया था, वैसे कोई है नहीं वैसे। बाकी
नहीं है तो कर लीजिए फिर, कर
ओके
लीजिए।
ओके, ठीक है सर, ठीक है, थैंक यू।
यस। सो और कोई क्वेश्चंस? ठीक है। सो
Yes,
चैट में
Mr.
Yeah,
Mrs. Sehgal, please ask your question. Or you can unmute Mr. Hanaman, please. Mr. Hanaman, please ask your question.
So in the meantime, I will just tell there is a IP India website, वहां पे जाके आप सर्च कर सकते हो। पहला देखिए in which class you belong to, कौन से क्लास में आप बिलोंग करते हो 45 क्लास में से, and then go for a search. So name search, phonetic search, ये दो searches आपको करने हैं वहां पे। Actual name search and phonetic search. ipindia.gov.in, वहां पे जाके पहले क्लास सर्च करिए, फिर उसके बाद ट्रेडमार्क सर्च करिए।
Mr. Sehgal, please ask your question.
Yeah.
Yes, please go ahead.
Yeah, I have a question. Basically, I was manufacturing something with a particular brand, my own brand in India since 92. So suddenly I realized in 2015, a American company in America registered the same brand name.
Okay.
So I got a little worried about it because I have been working so hard on it since 92. So I contacted a consultant over here and we applied it in Delhi, in fact, and we got the trademark for India in 2018.
Okay.
And with the document, I could only prove that I have been manufacturing since 2006.
Okay.
Those people in America are selling their products through a dealer in India on Amazon.
Amazon. Okay.
Okay. So now, since I am registered, how can I protect myself? Will they enter India by that brand name? Will they not be able to enter India by that brand name? Can I challenge that brand name being sold at Amazon?
Yes. Yes. Definitely Amazon, if you are able to raise the issue to the Amazon, so Amazon will take care of it. They will not allow them to sell under the same brand name. You can provide the details to them. Just for the sake of doing it, what you can do is you can start selling on Amazon. At least do a registration at least. Okay. Prima facie registration करके रखिए. That will give eyes to Amazon.
Actually, it's a very big company, a very powerful company. I will never be able to stand against them on legal suits or whatever. So if something happens, तो वो ये नहीं हो जाएगा कि छेड़ने वाली बात?
नहीं सर जी, ऐसे होता तो फिर ट्रेडमार्क और पेटेंट का कुछ यूज ही नहीं होता ना। इट्स नॉट दैट एक्चुअली। आप अगर डरोगे तो फिर ये ट्रेडमार्क के बिजनेस में रहने का कुछ फायदा ही नहीं है। एक ओपिनियन ले लीजिए, सच में आप डिपेंड कर सकते हो या नहीं। एक अच्छे कंसल्टेंट से वो सिर्फ एक देख लीजिए, अगर कर सकते हो तो आपको डैमेजेस भी बहुत ज्यादा रिटर्न्स में मिलेंगे, बहुत ज्यादा मिलेंगे।
मैं आपको after this session I would like to get in touch with you.
Definitely.
And I will tell you the name and everything. It's a very big company.
Definitely.
I have the Indian trademark.
We can give you a clear opinion, yes or no.
Okay.
For sure.
Okay.
Yes. Yes.
Thank you very much. Thank you.
Thank you.
Thank
Anyone?
you, Mr. Sehgal. You can just put your interested in the comment section, and we'll have somewhere in the team to get connected you to through
Fine.
Mr. Su-
I'll do
after. Yeah. Thank you.
Thank you.
Shall we move on with the
Who's
next session?
Hiteshji, would you like to ask something? And I would request other audiences also, if you want to ask, see, this is the golden opportunity wherein you having the expert answering your question one-on-one directly right now. So instead of just writing down in the chats, you can raise your hands now and you can ask, please.
हेलो
Yes, please go ahead.
गुड इवनिंग सर
Good evening. Good evening.
जी हमारा वेज फूड टेक का स्टार्टअप है जी तो मैं ये जानना चाहता था कि ये आईपी मित्र के अंदर में हम एक स्टार्टअप के लिए कितनी बार कितने समय तक वो फ्री में ट्रेडमार्क के लिए अप्लाई कर सकते हैं
5 साल स्टार्टअप का रजिस्ट्रेशन आपका 5 साल के लिए वैलिड होता है एंड आपका अगर टर्नओवर जो भी लिमिट है उसके आगे अगर चला गया तो वो भी नहीं रहेगा तो 5 साल के अंदर आप ये सब कुछ फैसिलिटेटर्स को मिलके सब कुछ कर सकते हो स्टार्टअप तो पहला रजिस्ट्रेशन आपको स्टार्टअप पे लेना पड़ेगा तभी आप स्टार्टअप के पास जा पाओगे ऐसा
लेकिन आईपी मित्र के लिए अभी मान लो कि हम 1 या 2 या उससे भी ज्यादा हम ट्रेडमार्क के लिए रजिस्टर करते हैं वर्ड मार्क और लोगो के लिए तो कुछ टाइम पीरियड या लिमिटेशन होती है या उसका कितनी बार रजिस्ट्रेशन कर सकते हो
अगर ये ट्रेडमार्क जो भी आप फाइल कर रहे हो नेम लोगो या कुछ भी वो सेपरेटली अगर वो स्टार्टअप ओन करती है ना ये स्टार्टअप फैसिलिटेटर्स कर देंगे जब तक आपका कंपनी स्टेटस स्टार्टअप है ना तब तक ये स्टार्टअप फैसिलिटेटर्स कर लेंगे विदाउट फीस
जी
ठीक है उनको गवर्नमेंट पैसा देगा
5 साल का टाइम पीरियड है ये
हाँ 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 आप समझ लीजिए जब आपका स्टार्टअप सर्टिफिकेट एक्सपायर हो जाएगा ना 5 साल में तब आपका स्टार्टअप स्टेटस खत्म हो जाएगा आप एमएसएमई में आ जाओगे फिर
ओके ओके थैंक यू
यस मोमिता शर्मा मिश्रा यू वांट टू आस्क एनीथिंग
Unmute Madhumita ji.
ठीक so we'll start with the next
Hello.
Yeah,
Thank you for your time. I just wanted to know, I have a startup and I already have a functional website and I already have a domain name for my website, but the logo, the company name has not been, I have not applied for a trademark. So how urgent it is for me to apply for the trademark of the logo as well as my company's name?
Okay, that's it, right?
I'm already doing business in my company's name. I have my letterheads and all, and just the urgency.
Yeah, just I'll tell you. There is no urgency to file a trademark application. You can do it after 10 years, 20 years, or 50 years also. You can claim the first user date. They say we had a last case. The person he was using his trademark since 1992, but he was able to claim documents since 2006. That is the reason he got protection from 2006 in 2018. Okay. So similarly, there is no urgency. But why I recommended do it ASAP? Because you will understand what are the threats. What are the coming threats? Because if you don't know who is coming or who may come behind you, or whether there is a real possibility of getting a trademark or not, or there will be similar companies floating around who also don't have trademarks, but those are similar like you. So those kind of things would be important to evaluate your startup in initial phases, right? So I would say grow it as soon as possible as a startup. Registration per se, there is no urgency. You can do it 10 years, 20 years, 50 years later. Just keep the evidences of when you started it. It can be done any time later on. That's
okay. Thank you. Thank you.
So I will move on with the next session so that I can cover everything actually. I hope just someone can speak out and tell me whether my screen is visible.
Yes, sir, it is visible.
Okay, so next is copyright. See, copyright is not that much essential for business, but still there are a few things that you can go for copyright. Copyright is a right given by law to creators of literary, dramatic, musical, and artistic work, and producer of cinematographic films and sounds. It's a bundle of right. So, अगर आप literature, dramatic, music बनाते हो, artwork बनाते हो, कोई film बनाते हो, brochures बनाते हो, website बनाते हो, so for that copyright is required. Otherwise, it's not required. Another benefit of copyright is the day you create something. जिस दिन आपने एक किताब लिखी, वेबसाइट पब्लिश की, the content is yours, अगर आपका content है तो you can बेधड़क mention करो copyright owned by you. You don't need to file a copyright application to mention that copyright is owned by you. It's legally allowed. Just make a note of it. Okay, this is the only protection. This is the only facet where you don't need filing, but it is essential as well. अगर आप सॉफ्टवेयर में हो या फॉर एग्जांपल इफ यू हैव टू बुक पब्लिकेशन, इफ यू वांट टू प्रूव, अगर आपको प्रूव करना है इन फ्यूचर कि आई वाज द फर्स्ट यूजर, अगर ये बात लिटिगेशन में जाती है, कोर्ट, if it enters the court, will court assume that you are the creator? No, because you don't have evidence. Because opponent is also saying that I have created this something before you and you before him. So there has to be something that validates this, right? Then court will ask for evidences. Bring the evidences, right? To avoid these things, delay in legal proceedings. Okay, if at all you think that there may be possibility of infringement or anyone copying your artwork, music, cinematographic work, or anything that is essential for our business, then only go for registration. Otherwise, registration is not mandatory. Okay. If you think, अगर आपको लगता है किसने, अगर कोई आपका वर्क कॉपी करने वाला है या करेगा, अगर ये कोर्ट में बात जा सकती है तो ही आप कॉपीराइट करिए, अदरवाइज नॉट रिक्वायर्ड. आप लीगली लिख सकते हो कॉपीराइट ओन्ड बाय ब्रेनियक और यू आपके नाम से, जस्ट टू गिव एन अंडरस्टैंडिंग. So all these things can be protected under copyright. Music हो गया, literatures हो गया, books हो गया, dance, painting, construction of the building, pictures. Business के लिए your website, brochures, blogs, standard operating procedure, presentations, software, advertisement, contents, books, videos. अगर आप manufacturing में हो तो engineering drawings also can be protected under copyright. Okay, video, songs, animations, these are the other facets that can go for a copyright application. So file करना जरूरी है? The answer is no. Yes, in case you need it as an evidence in future. Otherwise, not mandatory. ठीक है, फाइल करना जरूरी नहीं है. It's not mandatory. General terms of copyright is 60 years. In case of literature, and if literature, dramatic, music, and artistic work, 60 years is counted from the year from the death of the author. So generally it is 60 years, but in case of literature, dramatic, music, and artistic work, it is 60 years from the death of the author. If a company owns a copyright, it will be 60 years only, even if it is a literature, dramatic, or musical work or artistic work. Okay, if it individual owns it, then it is counted after his death. If anything that is owned by the company, any copyright is owned by the company, it is only 60 years. Okay, it's a big protection. It's a big protection. That is the reason you have to think about it. अगर आपको चाहिए तो it's really good. It wasn't criminal offense. Now it is not a criminal offense. Huh? Just it's wrong actually. Just I will strike it out for your sake. So it's not a criminal offense. It's no more a criminal offense now. Earlier it was a criminal offense. People were using it in a bad way to take legal action. किसी ने प्रोडक्ट डुप्लीकेट किया तो बोल दिया पुलिस को जाके इसने कॉपीराइट इन्फ्रिंजमेंट कर दिया, तो पुलिस यूज्ड टू रेड द प्रीमाइसेस, कस्टडी में लेते थे ओनर्स को, जेल में डालते थे, एंड देन सब लीगल प्रोसीडिंग होता था. बट देयर वाज रिसेंट अमेंडमेंट इन द इंडियन एक्ट. Intellectual property, anything that is related to intellectual property is now non-criminal offense. Means you can get monetary benefits only. किसी को आप जेल में नहीं भेज पाओगे अब. ठीक है, any facet of intellectual property, no one will go behind the bars unless and until it is criminal in different ways, not with respect to intellectual property. Okay, so now we are moving ahead with the business trade patent section. Okay, if you have any kind of a product, you can think about protecting it under patents. So any improvements, any small improvements, modifications that you think, or even if it is a composition, if it is a unique composition, always think about protecting it, because there is nothing that can give you 100% monopoly on your product. Anyone can duplicate your product. If you have patents, you can stop your competition entirely. Okay, entirely. For example, if people are into manufacturing, they must be knowing. Fiat is well known for that engines, Fiat. But no one duplicates their engine, right? They buy engines from Fiat. There are transmission systems. People are ethical or they are forced, I can say. Okay. Sometimes they don't have expertise, but can be duplicated? Yes, there is a possibility. There are people who can duplicate it. Why they don't do it? Because they have patents on those things. That is the reason they don't duplicate. People buy it. Okay. Okay. So now that is the reason patents are important for your industry. So never ever think that I will do a benchmark invention, a big invention, and then I will go for patent. बड़े-बड़े inventions ही पेटेंट होते हैं, ऐसा नहीं है. छोटे-छोटे पेटेंट चीजों पे भी पेटेंट होता है. Small things can be patented. Okay, that's the best tool if you're into manufacturing. अगर आपकी strategy अच्छी है, if you have a best strategy, you can fence your products by patents. You can have 100% monopoly. 100% monopoly. So this is the only tool that can give you 100% monopoly. Okay. Trademark is the highest valued asset for the company, and this is a tool, if you are into manufacturing, can give you 100% monopoly, which means marketing a kharcha zero. People will come to you. Start taking legal action, people will take license from you. That's it. One example, other people will come to you. Okay. Even if there are 100 competitors, अगर आपने एक को लीगल नोटिस भेजा और एक को कोर्ट में ट्रैक किया ना, तो बाकी सब भी सरेंडर कर देंगे. If you are valid, your claim is valid, provided. Okay. So patent is a government right, statutory right, given by the government in exchange of complete disclosure of your invention for a limited period of 20 years. So it is a limited 20 years. Okay. It becomes dangerous if it goes perpetual. 20 साल इसलिए दिया है कि अगर फॉर एग्जांपल फार्मास्यूटिकल ड्रग है विच इज लाइफ सेविंग, अगर उसको परपेचुअल प्रोटेक्शन दे दोगे तो इट विल बी डेंजरस फॉर द कॉम्पिटिटर्स, बी डेंजरस फॉर द कॉम्पिटिटर्स एज वेल एज टू द सोसाइटी. अगर प्राइस बढ़ा दिया 10 रुपए की चीज 1 लाख में उन्होंने डिसाइड किया बेचना, then it's a problem. That is the reason 20 years. Nowadays, with the fast moving technology, 20 years also seems to be very long period. Okay, but still it is 20 years. Okay. So there are 3 basic requirements of patentability. 3 requirements of patentability के. Novelty, new, नया. It should be new in the world. दुनिया भर में वो चीज नया होना चाहिए, नई होनी चाहिए. Okay. कुछ लोग आके बोलते हैं, some people say कि इंडिया में किसी ने नहीं बनाया. किसी ने कहाँ बनाया है? फॉरेन कंट्रीज में है तो वो नया नहीं है. अगर वो लिटरेचर में डॉक्यूमेंटेड है तो भी नया नहीं है. If it is published in any form apart from patent, still it is not novel. Any kind of publication knowledge, its novelty is gone. So first is novelty, new globally, not only in India. It should be new globally. Second is inventive step. Even if your invention is novel, it should not be an obvious to a person skilled in art. Okay. तो थोड़ा tricky definition है. Novelty आप check कर सकते हो. Inventive step is little difficult to check. So case to case basis पे you need an expert to give an opinion on this. Because just to give a small example, but it's not a literal example, I can say. Just a small example. I recently there is a glue stick available in the market, right? Earlier the glue used to be in the form of a tube. Tube लगा के हाथ गंदे करते थे. Now glue stick आता है very easy. पहले सेम फॉर्मेट में लिपस्टिक आता था. अब उन्होंने सेम पैटर्न में ग्लू स्टिक बनाया. इज इट ऑब्वियस? इज इट नॉवल? यस. अभी ग्लू अंदर गया तो नॉवल तो हो गया. ऐसा किसी ने बनाया नहीं. बट डज इट हैज इन्वेंटिव स्टेप? सो आंसर इज नो. सेम मैकेनिज्म, सेम कैप. नो. व्हाट इज नॉवल? नया क्या है? ग्लू व्हिच हैज मोर विस्कोसिटी. कैन आई पेटेंट ग्लू? यस, बट नॉट द मैकेनिज्म. Just an example. It's a very simple example to make you understand. Okay. And third is industrial use. Anything that you are going to go for patenting, it should be used by the industry or manufactured by the industry. Okay. These are the 3 requirements. So think that you have created something new. It should not be a drastically new invention, a benchmark invention, disruptive invention. Okay, small innovations also you can think about protecting it. Small inventions will have more value than complex inventions. अगर आपने rocket बना दिया, just an example, hypothetical example, you created a very big, strong missile or a rocket, just an example, to land on a moon. Very good, very innovative. How many people will do that thing? Very few people. One or two companies are doing it. What will be the valuation? I don't know. But if you created an app like Uber, where everyone needs it, उसके ऊपर अगर पेटेंट मिल गया आपको, nothing like it, right? Right? Post it. Everyone has that post it, right? उसके ऊपर अगर आपको पेटेंट मिल गया तो think about it. Amazing, right? The bubble wrap, just an example, bubble wrap. Every packaging industry uses it. Amazing, right? Small invention, everywhere applicable. Very easy. So smaller inventions will always have higher value. Don't think that you have to do something very disruptive. Okay. Small modification also can be patented. Just make sure that you have a right mindset so that you can approach every time, check whether it is patentable and move ahead and file the patents. Okay. So it is a little complex than trademark. Here, drafting of the patent application is also crucial. Novelty, checking how it is novel, infringement possibilities. There are various things that you have to check. So whenever you enter into this patent arena, things are going to be expensive and little difficult. Okay. So what can be protected under patents? Product, process, composition of matters, machines, and improvement. All improvements, provided they are new and inventive globally. So all inventions are not patentable. All inventions जो होते हैं उसको patent नहीं मिल सकता है. Scientific discovery, like light speed, it was there. Someone calculated it. Gravity, it was already there. Someone said it is gravity. Okay. So scientific principle E is equal to mc square. नहीं पेटेंट हो सकता. ठीक है. Business methods like Amazon, Flipkart, Snapdeal doing same thing. Grofers, Big Basket, now Swiggy doing the same thing. Okay. Business methods cannot be patented. Just make a note of it. Mere softwares, no patent for mere softwares. If your software has a technical advantage, then only you can patent it. Otherwise, you cannot. Just make a note of it. And every country has their own laws. Okay. Specifically in India, as a developing country, we have a lot of restrictions in comparison to other countries. Okay. So the most liberal country is US, then it's Europe, Japan, Australia. So in nutshell, जो भी कंट्री डेवलप्ड है उनके यहाँ पे बहुत सारी चीजें पेटेंट के अंडर प्रोटेक्ट हो सकती है. बट एज अ डेवलपिंग नेशन वी हैव लॉट ऑफ रिस्ट्रिक्शंस. व्हाई? बिकॉज वी वांट पीपल टू ग्रो फाइनेंशियली फर्स्ट. अगर ज्यादा लिटिगेशन में पैसा डालेंगे तो ग्रो कब करेंगे ना. इसलिए अभी थोड़ा स्लो है. बट वी ऑल एंटरप्रेन्योर्स शुड पुश एंड बिल्ड दिस नेशन. दैट इज व्हाट वी आर डूइंग ऑलरेडी. तो ये भी मूव हो जाएगा इन नियर फ्यूचर, पेटेंट्स भी. ठीक है. This is a general procedure. Patent first step यहाँ पे भी same है. First step is same. You have to do a search first, then only go for patent. Otherwise जितना पैसा आप patent पे डाल रहे हो ना पूरा waste हो जाएगा. Okay. So patent में you can file a provisional application if your product is not ready. आपका अगर product ready नहीं है, provisional पे जाइए. 12 महीने मिलेंगे आपको complete file करने में. When you file a complete application, you cannot change the content. You cannot change, add or delete the content from the complete specification. That is the reason it's very crucial. In case of litigation, no one is going to check your product. ये मेरा product है, जैसे trademark में होता है. This is my trademark. This is my trademark. Okay. Patent में नहीं. This is my product. This is my product. No. What is written in the document will be checked. आपने document में claim क्या किया है वही देखेंगे लोग और फिर उसके बाद infringe हो रहा है कि नहीं पढ़ेंगे, देखेंगे उसको. So infringement के लिए ये document is crucial. That is the reason people charge hefty amount for drafting complete specification. Okay, it's very crucial. अगर sometimes ऐसे हो सकता है, अगर claims बहुत narrow हो गया ना, तो आपको patent तो मिल गया, but सामने बैठ के अगर कोई copy कर रहा है, थोड़ा modify करके, उसका use नहीं है, तो patent इतना strong होना चाहिए कि थोड़ा बहुत modify करके कोई भी वो launch कर नहीं पाएगा product. Okay, no one should be able to launch similar product with small modification, 5-10% more modification. Then it is a strong patent. Otherwise, very weak patents can be drafted by anyone actually. So be little cautious if you are into manufacturing or innovation of new products, or your startup is basically focusing on innovative products only. After filing complete file करने के बाद it goes for internal scrutiny, classification allocation of classification happens, then it goes for publication. Publication can be preponed. Publication हम prepone कर सकते हैं, but is it required? No. In case you want to expedite the grant, then only it is required. Otherwise, no. Request for examination. If it is not filed, your patent will never be examined. Okay. As early as possible, you can file. You should file request for examination. Okay. Because from the date of request for examination, your patent application gets into the queue. There is a long pending queue. Okay. So there are a few schemes available for startups. Expedite route is available for startups, for MSMEs, and for female applicants. So if you are a startup, if you are an MSME, or if you're filing a patent application as an individual and you are a female, or you have one of the applicant as a female applicant, in that case you can go for expedite route. By that route, you can expect a grant for a patent in 12 months to 18 months time. Okay, expedite route अगर आप opt करते हो तो जल्दी patent grant होता है. Otherwise, 2 से 3 साल लग सकता है. It will take 2 to 3 years of time. So examination report, this is a normal procedure. Even if you have done a search, examiners will still do a search, and they will say that why your patent is not, invention is not patentable. You will get 6 months to answer it. Then it will go for hearing. Hearing is always an online hearing. Hearing online होती है, वीडियो कॉन्फ्रेंस थ्रू. तो आपको पेटेंट ऑफिस जाने की जरूरत नहीं है. ठीक है, सब कुछ ऑनलाइन होता है आजकल. वहीं पे पता चल जाएगा कि whether your patent application will be accepted or rejected. अगर rejected है, तो you can approach High Court, review petition डाल सकते हो. If it is granted, you have to pay yearly maintenance fees. Grant हो गया तो yearly maintenance fees भरना पड़ेगा. Anytime your patent can be challenged by a third party. 20 साल के अंदर any third party can challenge your patent. Before grant, pre-grant opposition, after grant, post-grant opposition, with the patent office 12 months, till 12 months. After that, they can approach High Court and oppose your patent. Okay, so this is general procedure. So these are the different things that you need. The first step is always do a patentability search to check whether your invention is patentable. Whenever you want to launch a product in the market, specifically अगर US में या यूरोपियन कंट्रीज में आप अगर प्रोडक्ट लॉन्च करते हो तो एफटीओ बहुत जरूरी है. अगर आपके ऊपर कोई इन्फ्रिंजमेंट केसेस आ सकते हैं या नहीं, देखना इज वेरी इंपॉर्टेंट. ओके, इट इज वेरी एक्सपेंसिव. फॉर एग्जांपल, अगर if you're talking about just US, you take it to handle, just to represent the case in the court, it will cost you somewhere around 1 CR in INR. In INR, I'm just talking 1 to 4 CR in INR. अगर आप यूएस में एक लिटिगेशन बैटल फेस करोगे पेटेंट का, तो आपको 1 से 4 CR तक खर्चा आएगा. So that is the reason, अगर आपका मार्केट टारगेट इज यूएस, FTO is must for you. US, Europe, China, any other country. इंडिया में या still people are learning. अभी चलता है इंडिया में, it's not that much required. But अगर बहुत competitive domain है तो FTO is must. So patent is different, FTO is different. Even if you're launching a product which does not have patent, still FTO is recommended, depending upon the competition you have. Okay, FTO से ये भी कर सकते हो आप, अगर कोई duplicate करना है आपको product. If you want to duplicate any product, you have seen a product in somewhere and you got fascinated by it. Now I want to launch it. Without filing a patent, you can do just FTO. Check whether there are any live patents on that. If you have an FTO, launch the product. Just don't duplicate it. And when I say duplicate, you can adapt the same technology, use the same technology. Don't copy paste it, because there are other laws. Copyright is there, design is there. People will come against you. Counterfeit law is also there. So duplication means you can get inspiration from that technology, use that technology as it is, but design up it in a different way. Okay. Then is patent landscape. This is if you have budget, you have to do it. Then only you can do it before starting R&D. Infringement analysis, patent आपके पास है. You have to keep on checking, right? Who is infringing your patent? Otherwise, it's waste of money. So nowadays, people don't want to get into litigation. But understand this: 90% of the people don't want to get into the court. Like you, your opponent also don't want to get into the court. Court में कोई जाना नहीं चाहता. तो out of court settlement ही होता है 90% of the cases. Just notice भेजो, everyone will agree to it. They will come on the table. Arbitrator अगर आप appoint कर सकते हो तो करेंगे. एक resolution पे आएंगे. licensing agreement हो जाएगा. That is how it is. So no one will always go to the court. Okay. Next is competitor watch. That is must if you are into competitor domain. Okay. So just an example. I want to just ask you a question. How to use inventions like iPhone. So do you think that iPhone invented touchscreen? Just to check whether you are still there with me. Did Apple or Steve Jobs invented touchscreen? Just I want to see the answers if you can answer this. Okay, I got one answer, no. Shashank. So there is Mr. Datta. I will I'll get back to you after this topic. You can answer. So anyone says that anyone contradicts to Mr. Shashank that touchscreen was invented by Steve Jobs or Apple? So I assume everyone agrees to it. Yes, that's correct. So touchscreen was an old invention. I think so. It was done in 1956-57, and Steve Jobs was the first person to adapt it. Okay, that is the reason Samsung was able to launch touchscreen phones. The battle was on single button. They had an infringement issue with respect to single button, not on touchscreen. Okay. Just to give you an example, highest valued patents, Velcro. It was actually it's a highest valued patent way back in 1958. Okay. Now it's a big company. You must be knowing this. Okay. Velcro is a trade name. It's called hook and loop arrangement. Velcro is a trade name actually again. Velcro. This technology is called hook and loop arrangement. Hook and loop arrangement. Okay. Next is design registration. So before moving on to the design, I would like to take questions. So I have stopped sharing. Yeah. Anyone has any questions? They can unmute themselves and please speak. So Mr. Datta, you can please, if you want to speak. I assume that no one has any questions.
Mr. Datta, would you like to ask? And there's someone, the name is not mentioned, but it just says 2 dots. So if you have a question, please ask. Unmute, Mr. Datta.
So in the meantime,
आवाज आ रहा है?
हाँ जी, हाँ जी. Yes, speak up, please. You can speak.
Ask your question, Mr. Datta. We can hear you. Please ask your question.
यस मैम, एक्चुअली मेरा क्वेश्चन ये था कि अगर हमने कॉपीराइट ये कर दिया, रजिस्टर कर दिया, तो माय क्वेश्चन इज दैट हाउ आई कैन फिगर आउट वेदर माय कॉपीराइट इज बीइंग यूज्ड बाय अदर्स और नॉट.
You have to see, keep on checking what your competitors are doing. There is no other way. No one is going to come and inform you.
Yes sir.
आपको कोई आके बताएगा ये आपका कॉपीराइट इन्फ्रिंजमेंट हो गया है या कोई कॉपी कर रहा है, तो आपको वॉच रखना पड़ेगा.
नहीं, सपोज ऑनलाइन मैंने वीडियो का कुछ क्लिप्स ये किया, तो उसको दूसरा कोई यूज कर रहा है या नहीं कर रहा है, या अगर करने जाता है तो इमीडिएटली उसको कुछ ये हो जाता है कि दिस इज ऑलरेडी कॉपीराइट ऑलरेडी टेकन, यू कांट टेक इट एज
नहीं. फॉर एग्जांपल अगर YouTube पे कुछ चीजें लोड हो रही है, YouTube टेक केयर ऑफ इट, YouTube इज चेकिंग इट, बट अदर प्लेटफॉर्म्स को मुझे पता नहीं है. अगर किसी ने कुछ अदर, फॉर एग्जांपल मैंने मेरी वेबसाइट पे ही कुछ डाल दिया, YouTube पे नहीं है, सीधा वेबसाइट पे होस्ट कर दिया, उसका चेक नहीं होगा ना. तो आपको चेक करना पड़ेगा, ऐसा किसी ने खुद की वेबसाइट पे डाला है, YouTube है तो वो चेक.
वीडियो क्लिप्स एंड कंटेंट्स ओनली, क्योंकि कैसे अभी वो तो समझ में नहीं आएगा कि किसने यूज किया है, कर रहा है या कैसे, तो अपने आप वो मतलब रहेगा कंटेंट, राइट, अगर कॉपीराइट टेक लिया है तो.
यस, कोई आपको बताएगा नहीं, आपने लिया है तो भी नहीं बताएगा, नहीं लिया तो भी नहीं, ऐसा.
अच्छा.
So there is one interesting question here. If I am duplicating product of branded companies, it's not a criminal cognizable offense. So I would like to answer this because this is 3 times the person has asked. See, first thing, duplication of technology means, for example, I am adding spring to my shoes. Okay, so can I add spring? Yes, but can I duplicate the same design of that particular shoes? The answer is no. There is not only intellectual property, there is counterfeit law also. Okay, counterfeit law. Again, I can add that you are misleading the public. Okay, so there can be various ways to get it criminally, make it criminal offense also. Okay, so when I say you can adapt the technology, you can use that spring. Just an example. अगर आपने spring डाल दिया, okay, now there is no patent on spring, but the competitor is using. You got an inspiration. They don't have patent of spring in India. आपने spring डाल दिया. Spring का dimension अलग है, design अलग है, सब अलग है. Shoes का shape अलग है. Then it's okay. So again, I'm telling you, duplication is again a crime. I'm not telling you duplicate. I'm telling you adapt or use the same technology. I hope I'm clear on this. Huh? So even if there are no patents, make sure that you are not duplicating it. Okay. So let's move on to the next topic. I assume there are no questions. Deepak, you have any questions? Mr. Deepak Gulati. Okay, fair enough.
Probably we can come back later
Yeah.
if they have any questions.
Yeah. So next is design registration and the industrial design recognition. Anyone is speaking?
Deepak ji, you want to ask your question? Mr. Gulati, please ask your question. Can you help them unmute, please?
Yes. Sir, actually, I had a question and I had written that in question answer also, but somehow I missed the presentation due to a part of presentation due to network. Sir, my question is, we are a pharma company and we have designed a bottle, and that bottle has been patented also. That design is patented.
Okay.
Now, people have started copying that bottle. So, can we defend this?
Yes, start sending them legal notices ASAP.
Okay. So when I talk to them telephonically, they all say that we have taken a legal opinion that there is no design patent for bottle.
So you are sure you have taken a design registration?
Yes, sir. It is with me. Registration
Then fine.
certificate is
So
with me.
why you are thinking what they think, what their opinion is all about? आपको अगर सही लग रहा है तो पहले legal action लीजिए. Legal action में पहले notice भेजिए.
Okay. And even if we are in contract manufacturing, we can do that.
Can you elaborate that, please?
Sir, basically we are a contract manufacturer of pharmaceutical products. So we are manufacturing for third parties, the brand owners. A bottle is used which is patented by us. Design is patented by us. So still I can send a notice to.
ना आपकी जो pharmaceutical company जिसको आप बेचते हो, they are giving order to them, right?
Yeah, they are giving order to me, and they have given order to my competitors also. और उनसे उन्होंने सिमिलर बॉटल बनवा ली है और वो बॉटल सेम एग्जैक्टली सेम देखिए आई विल से दिस इज सेम आल्सो एंड सिमिलर आल्सो. कुछ लोगों ने बिल्कुल सेम कॉपी की है और कुछ लोगों ने सिमिलर बनाई है.
सिमिलर वालों को छोड़ दीजिए, सिमिलर वालों को स्कोप है डिफेंड करने के लिए, बट सेम वालों का पहले एक्शन लीजिए एंड सेम नोटिस आप जब भेजोगे आपके कॉम्पिटिटर्स को तो सेम नोटिस आप फार्मास्यूटिकल कंपनियों को भी भेज दीजिए कि कॉपी टू देम कि मैं हमने ऐसे ऐसे किया है. तो जब उनको लगेगा कि आपका सप्लाई कम हो जाएगा तो दे विल टेक अ करेक्टिव एक्शंस.
ओके.
और उनको बोल दीजिए कि डिजाइन हमारा है तो हमको व्हाटएवर रॉयल्टी यू वांट, वो बॉटल कितना मैन्युफैक्चरिंग कॉस्ट है उसके ऊपर 5% 2% जो भी आपको चाहिए वो आप ले सकते हो उनसे.
ओके.
बॉटल की कॉस्ट के ऊपर 5 या 2%.
ठीक है, डन. तो लीगल नोटिस मुझे भेजना पड़ेगा फर्स्ट थिंग, और सेकेंडली आपका ओपिनियन है कि सिमिलर पे नहीं हो पाएगा, सेम पर हो जाएगा.
सेम का आप इमीडिएट एक्शन लीजिए. यस.
ओके. थैंक यू सर. थैंक यू.
Yeah. So move on to the next topic. Design abhi we are going to cover. So that's how I will be covering this thing here. Okay, so industrial design recognition, the creator of new or original feature of new shape, configuration, surface pattern, ornamentation and composition. Just a minute. Please go. Composition of lines, colors applied to an article which in the finished state appears to and are judged solely by the eyes. Just मोटा मोटा आप देख लोगे तो अगर फॉर एग्जांपल मैं दो चीजें एक साथ रखता हूं अगर वो आइडेंटिकल है इफ दे आर सेम देन इट इज एन इन्फ्रिंजमेंट. ओके, जस्ट फॉर एग्जांपल आपके आपके घर में एटलीस्ट दो फोन होंगे of two different brands, right? But whenever you pick a phone, you will be able to recognize which is yours and which is not yours, right? Because they are rectangular, still different. That is the reason you can recognize them. So it's a very competitive word. That is the reason you will see that जो buttons होते हैं right volume के या यहाँ वहाँ, they have made position wise changes so that you can recognize it. Even if it is rectangular, the rectangular shape is again a little different. किसी का wider है, किसी का narrower है, कुछ भी है. So design registrations are awarded to anything that is aesthetically new, visually new. Okay, so same thing goes with the automobiles. आजकल automobiles के अंदर there is the same engine. Okay, engine is same. Okay, sometimes you will see bodies also same. They are using same platforms, same body. Also they are doing सिर्फ branding अलग हो रहा है. So few companies are doing like Suzuki and Toyota. Okay, there are various vehicles you will see that way only. So if it is aesthetically new, you will see that can be protected under design registration. Mobile is one example. Automobile body is one example. Shoes लीजिए. So anything that is new can be protected under design registration. Okay. So patents के लिए मैंने स्कीम बताया नहीं, I think so, right? So patent के लिए भी स्कीम है और डिजाइन के लिए भी आई है. This slide ये थोड़ा सा अलग आगे आ गया. So I will complete this with patents first. This is applicable for patents and design. Okay. So I think I will take this after design registration. Yes, I will take this after design registration for patents. Okay. Okay. So anything that is aesthetically new can be protected under design registration. Anything जो visually नया है, anything. So simultaneously उसका patent भी हो सकता है और design भी हो सकता है. Okay. You can go for patent and design both. If technology is new, go for patent. If only it is new aesthetically, go for design. If both are new, go for both. Design is cost effective. कम पैसे लगते हैं, 10-15 हजार में हो जाता है. Very easy to get registered. 99% register हो जाते हैं. Rejection rate is very less. Okay. Second thing, only images are required. What are the novelty of the images? That's it. 6 months के अंदर आपको design registration मिल जाएगा. Okay. And protection is for 15 years. 10 plus 5. Only once you have to renew. And then. Hello. Can you mute yourself? Someone is there. Can you mute? Okay. Design term is only for 15 years. Patent is for 20 years. Patents may you have to renew it every year. Design only once for next 5 years. Okay. Cost effective. Images are required. Easy to apply. Patent and design. Both you can go if your product is technically novel and aesthetically novel. Otherwise, you can go for design or patent. Either ways. So just to give you an example, everyone is selling same thing, elongated bottles. But even if you see the colors, in spite of being blue, they are not same blue. The what I can say, the marks that are there on the bottle, the creases that are been made on the bottle, those are also different. The curves that are there, the shape of the bottle is entirely different. Okay, but the content is same, water. Okay, so every product that is aesthetically new, you should go for design registration. You should go. Just make a note of it. Nowadays, what has happened? Be it a patent, be it a trademark, be it a design registration. Creative people are there in the market. They will get inspiration from you. I have seen this happening. आपका ही चीज का वो पेटेंट बनाएंगे, ट्रेडमार्क बनाएंगे या डिजाइन बनाएंगे. They will get everything from you. Maybe they are associated with you somehow. they will get a registration because no one has done it. Government will not come and check किसने पहला किया था. अभी उनको ट्रेडमार्क मिल सकता है या फिर पेटेंट भी मिल सकता है या डिजाइन भी मिल सकता है. Just worst case scenario I'm telling you. Then these people will again take a legal against you on, and then you have to sit and prove. No, I was the first person to do this. मैंने पहले किया था. मैंने फिर registration नहीं लिया है. But this is my work. Now this has become a chaos for the companies. Okay. अगर आपको इससे बचना है तो कुछ भी है पहले प्रोटेक्ट कर लीजिए. That's what my recommendation is. Whether it's a trademark, design, or patent. Okay. Copyright, just you can think about skipping it. So this is just an example. Rectangular phones, different bands, they will look different. They will look different. Camera positioning, front screen positioning, everything is different. Okay. Design infringement is again civil suit. Very easy. If it is the same product, you will take it. Can be everyone can take identify it as the same product and legal action हो सकता है. Design के साथ even counterfeit law also can come in. Okay, counterfeit law, duplication of the products. There are various laws that can come in with design registration. So it can become a very complex and very strong case if there is an infringement of design. But make sure that you protect it ASAP. If you think that something is new, protect it. कोई और आपको आके infringement एक्शन नहीं लेना चाहिए और फिर जाके आपको प्रूफ करना पड़ेगा कोर्ट में कि I was the first person. ठीक है. So government schemes specifically, again like trademark, there are patent facilitators. Okay, for patents specifically. On the Startup India website, you can contact those facilitators. They will do everything with only government fees. You have to pay just government fees to them. Government will pay them their professional fees. The professional fees is very less. That is the reason we are not part of this startup facilitator scheme. And recently, the government has stopped paying these facilitators. There is little chaos. Okay, that is the reason we are not part of it. But this is a scheme that is available. You can opt for it. Next, if you are a startup or an MSME, okay, just excuse me with the name, spelling of startup in the title. Okay, if you are a startup or an MSME, you will get 80% reduction on the government fees. Here also I have made a mistake. It's professional nahi government fees. Just I will correct it here itself. Okay, so it's GOVT fees. So startup facilitators, second is government fees. There is 80% reduction in the government fees. Professional fees will not change. Professional fees will not change. If you are an MSME or a startup, there is 75% rebate on the total expenditure that you have made on patents, either domestically or internationally. And there are other schemes also. You will get somewhere around 25,000 to 2 lakh rupees. Okay, on each patent that has been granted to you. These are the specific schemes available based on the states as well. There are some central government schemes. There are some state government schemes. So you have to contact company secretaries to get these rebates. Okay, so startup facilitators, they will do it free of cost. 80% reduction. No need to approach anything. You just need to show your MSME certificate. But if you want 75% rebate on your patent expenditures, then you have to contact company secretaries who are expert in getting this rebates back. Okay, so it's very much possible. Everything that you have spent domestically or internationally, up to 20 lakhs, you can get it back. 75% of it, or total expenditure के 75% आपको वापस मिलेगा. So contact your company secretaries. They will get these funds for you. They may help you in getting these funds. Or there are various consultants also available. Okay, those who work specifically with government. So you can contact those experts for this 75% rebate. Okay. This expenditure, it includes patents and design as well. Okay. And for design, there is only 50% reduction. Well, yeah. Yes, I think so. There is a 50% reduction in the government fees. 1/4, 40%, 1/4% reduction in the government fees for design application. For normal companies, it is 4,000. For individual or for MSME or startups, it is 1,000 government fees. Okay. So next is IC circuit layout. Most of the companies don't do it. There is very less filing in this. If at all you want to do it, you can opt to do it. But if you are specifically into electronic products, and if you are creating a new IC circuit layout, then you can think about getting protection under this category, IC circuit layout design. Okay, no other people are still, not much people are getting protection for their layouts. Okay, because it's a weak protection. Patent is the strongest protection for the technology. Next is design registration, little weaker. When it comes to brand, trademark. For every brand, trademark is important. Okay. So next is trade secret, as everyone is entrepreneur over here. That is the reason I just want to tell you about this trade secret. Trade secret company का सबसे बड़ा asset होता है, apart from trademark, copyright, and patents. Why? Trade secret is any practice or a process of a company that is generally not known outside of the company. Information considered a trade secret gives a company an economical advantage over its competitors and it's often a product of internal research and development. Okay, so मेरे हिसाब से trade secret is the most important facet of any business. I will tell you why. Okay. So leave about formulas, patterns, compilation of data, devices, methods. It can be a trade secret. Techniques also can be a trade secret. Processes can be a trade secret. Customer list can be, and manufacturing process can be. Okay. So for example, I have a big money. Suppose I have a lot of money, like Ambani's and Adani's have a lot of money. And tomorrow I decided that I want to start what I can say, a business in automobile industry. Okay, मुझे टेस्ला जैसा कंपनी बनाना है, या फॉर एग्जांपल महिंद्रा को कंपटीशन देना है, ये है. Okay, I have a lot of money, I can put manufacturing setup in place. Leave about whether I will be able to brand or not. Sell करना अलग बात है. Okay, ऑटोमोबाइल छोड़ दीजिए, शिपिंग इंडस्ट्री में देखते हैं. शिपिंग इंडस्ट्री वेयर ब्रांड इज नॉट दैट मच रिक्वायर्ड. तो क्या करेंगे? I will hire people, best people who are working in that industry, right? तो वहां से हम people उठा लेंगे. Man are your assets, people are your assets. They will come with all the knowledge that is required. अगर आपकी कंपनी उसमें pioneer है, your knowledge will be taken away by most of the people and they will duplicate it for the competitors. उनको सैलरी अगर ज्यादा मिल गई तो they will start duplicating it. That's the simple way. Okay. So make sure that कुछ trade secrets, आपके पास कुछ चीजें होनी चाहिए that you mention. This is a trade secret of the company. Take it on writing, but this is a trade secret. In India, there is no law, no trade secret law. Okay. So non-compete agreement, non-disclosure agreements are required to protect trade secret. Non-compete, non-disclosure agreements. Okay. There is no other law that can protect trade secret. But when you start saying that this is my trade secret, this exclusively belongs to me, then people will think twice or thrice before taking any legal action, before copying it, right? Otherwise, it becomes difficult. Okay. Next is when you hire a marketing person. Why generally people hire 10 years, 15 years plus marketing person? Reason, they come with clients. They already have clients. They will just bring those clients to your table. Simple as that. Right? And same thing can happen with you. आपका client list है, prospect list है, तो simply चला जाएगा दूसरी company if they're able to hire your topmost marketing person. तो उनको बताना पड़ेगा, this is my asset, it should remain with you. तो आप अगर बताओगे नहीं तो people will take away with them. Okay, so just make sure that you are keeping this as a trade secret in your company. Non-disclosure agreements, non-compete agreements should be there in your employment agreements. Okay, this is the biggest threat for the companies apart from patents, trademarks. वो तो आपने कर लिया, उसमें तो प्रोटेक्शन मिल जाएगा, इतने जल्दी डुप्लीकेशन नहीं होगा. बट जो छोटी चीजें हैं जिसकी वजह से आप सक्सेसफुल हो आज, वो चली गई तो क्या कैसा होगा? It becomes difficult. So manufacturing process and customer list, these are the important things for me, and I think that is more relevant for any business. Okay. Next is geographical indication. So I will not take much on this because this is specifically like Kolhapur chappal, Darjeeling tea, Nagpur oranges. So this is most of the things are required for agricultural people, and as I see that we don't have much crowd from agricultural domain, it is not important. just to give you a glimpse, any geography which is known for that particular product can go for GI, geographical indication. Okay, it cannot be owned by a single person. It has to be owned by an association or a group of people, and they will decide whether who at all people are the people who can use this as a GI. Okay, even products like Kolhapur Chappal are protected under GI actually. Just to give you these examples. Okay, next is plant variety protection. I will again not take it. So next is okay. So these are the agreements. Generally, why I have shown these images, because everything starts and ends with money, right? Everything starts and ends with money. So everyone is here to earn money. आपकी competitors होंगे या फिर जिनके साथ आपके grudges है. So everything starts and ends with money. So these are the simple agreements that everyone should have in place. Agreement with investors, engagement and exit policy, non-disclosure agreements with third party and your employees, non-compete agreements wherever possible, inventor assignment agreements. If there are inventors who are working on some inventions, they should assign inventions to you. Okay. Employee agreements. Employee agreements are not so watertight. In India, we are lenient. चलता है ले लो सब. ठीक है, but whenever you think that there are some over smart people, go for it. Do strong agreements with them. Work for hire, dealer, distributor agreements, research collaboration agreements. These are the simple agreements that are essential for any business. With this, I think so you will be able to succeed in your business, at least with respect to IPR. Rest will depend upon how strongly you market, how well you understand the pain points of the customers, and then you can thrive in this business, I guess. So just to give you understanding, these are our clients in very quick. And our global services. So we also help in consultation, coaching to develop patent portfolio, trademark portfolios, and help them in taking legal actions. So these are the things. And this is my YouTube channel where if I have missed something, you can scan it and you can just subscribe to this channel where most of the information is there, which maybe I have covered or may not be covered. So you can follow me here. Again, we have a podcast channel. You can scan and just register. We invite entrepreneurs, inventors on this podcast channel, and these people share their experiences over here. Okay. So apart from me, you can learn from all these experts actually who are working in this domain by just subscribing to this channel. Okay. So Built on Brains. It's a Built on Brains channel. And these are the two books available if you want to do it something on your own. These are books available on Amazon. You can definitely buy it. So as of now, it's only Kindle copy available. I'm not selling any hard copies. So that's it from my side. So if you need any contact details, I think so you can get back to the what I can say, Miss Sonia. She may help you in connecting with me. So that's it from my side. If you have any questions, anything that you want me to cover, let me know.
Certainly, Sumit. The only thing I would like to say is if you have any questions regarding the last topic he's covered now, so you can ask right away. And also, like Sir has mentioned, you can follow him. You can buy his books, and you have the YouTube channel of his also. And we'll be also uploading this session on our YouTube channel soon. And meanwhile, for your personal questions, reference, and queries, and you want some direction, and you want to get in touch with him, we'll find a suitable time advisable by Sumitji, and our team member can get you connected. So we have pinned our number, we have pinned our email ID. You can, get in touch with us through any medium. You can call us also, right? And so right now, if there's anything, please you may ask now so that we can find a session then.
So there is one more interesting question: duplication or copying? Is it
Yeah,
cognizable
I was about to
or
say.
non-cognizable offense?
Yeah.
It can be, see, it is based on your intentions. If the product is duplicated, I can say that you are there to deteriorate my brand, ruin my image, okay, spoil my image in the market. I can get you under this cognizable offense as well. Even if IPR is not there, I can, with your intentions, I can place it or frame it in a different way and still make it cognizable. There are ways of making it cognizable. Okay, when it is pure intellectual property, straight away trademark infringement hai. Yes, it's civil suit. Patent infringement, civil suit. But duplication, there are various things can get into. Duplication is very complicated. Definitely, you can be put behind the bars also. Someone can be. That's for sure. Okay. So I hope I have answered this question very straight and clear. So make sure that you don't do these things if you are at all intending to. That's what my recommendation is. So any other question?
There's another question in which I think Shalini ji is asked that in which category that software code is protected?
Software code, copyright. Software codes under copyright. If it is software technology, you can think about patenting it as well. But if it is only software code, copyright. Anything else? Anything anyone wants to ask? Any questions? And also, I would love to get some feedbacks from you. If at all you would be able to give small feedbacks before you leave, that would be really great, so that I can improvise my next presentation segment. So.
If you ask me as a presenter, I think the presentation was so great and you had been so patient and answering everybody's questions and queries throughout, like taking breaks. I think that was a great idea, wherein everybody was, understanding one chapter and going to other and making those things clear. So I think for me as a layman who didn't know anything about this, I got so much information, like, even I can talk about it now. So the session was really great. And I think everybody has benefited from it. It was very, very insightful. And now we have you've also mentioned so many topics as well as books related to it and YouTube channels wherein somebody if has missed something and forgotten can go back and revive and get through it. So it was a wonderful session and a beautiful presentation.
Thank you very much. Thank you very much for having me. And I got one response, Mr. Shashank, a very informative session. Thank you very much. And a lot of thumbs ups. Thank you. Thank you. It was a pleasure to have present in front of you people.
Thank you, Sumit. And I think people are really getting fond of you. So we're going to have you back again soon on popular demand, we can say. So we can, request our participants, please leave in your feedbacks. If you think there's any other topic you want, Suniji, please relate it to his topic in session only. And whatever you want to know, we can have him back again. And since Udyamita is here to support and get you, we really challenge and strive to get the best of the mentors. So I think he's the best one in his field. So you can, just take out your time and your queries and we can get you connected to him. And he's already given you so many ways also. So thank you, Suniji, for being with us today. It was a wonderful session. And I think I'm going to thank you on behalf of my participants also. And I can see so many of them are leaving beautiful comments for the session here. So thank you for joining us. Thank you all the participants and we may join together soon. Thank you. Have a great day.
Thank you. And have a nice evening. Thank you. All the best for everyone. Thank you.
Thank you.